Yeah, looks like everything's working. Great. So I'll begin by introducing myself as your host. My name is Endangered Lang. For those of you who don't know me, I'm the Executive Director of PHAP, which is short for the International Association of Professionals in Humanitarian Assistance and Protection. And it's my great pleasure to be welcoming all of you today for this virtual discussion. It's great to see so many both familiar names in the list here, and also I think a few people joining us for the first time. Great. So having said this, we'll move on to today's session, which is a session in our series of online expert briefings in our thematic track looking at humanitarian law and policy issues. Today we're looking at the topic of hostile intent and civilian protection, looking at lessons from recent conflicts. So not strictly speaking, perhaps an issue of international humanitarian law, as we may learn later in the hour, but a concept that has a tremendous implications for protection of civilians. And I won't give everything away, but I think it's a concept that maybe is not well known or understood in the humanitarian community and what the implications may be. So it's very exciting to have with us as a guest today Bonnie Docherty from the Harvard Law School International Human Rights Center, or Human Rights Clinic, sorry, who has been conducting some research into this issue and is going to be sharing with us today some of what she's found. Bonnie is an expert on disarmament and international humanitarian law, particularly involving civilian protection during situations of armed conflict. And since 2001, she's played an active role as both lawyer and field researcher in the campaign against cluster munitions. Then more recently, Bonnie has advocated for a ban on fully autonomous weapons and stronger regulation of incendiary weapons. She's investigated the conduct of war and civilian casualties in a number of countries, including Afghanistan, Iraq, Israel, Gaza, Libya, and Ukraine, and has published reports on U.S. military training and the rules for distinguishing combatants from civilians. So thank you so much, Bonnie, for being with us today, and we're very excited to give the floor over to you for your presentation.
Thank you very much. Thank you, Anhard, and PHAP for hosting the briefing. And I also want to thank all of you for joining the conversation today online, and I look forward to having some discussion as well as filling you in on some of our recent research. So today I want to discuss an issue that has had a notable impact on civilian protection in recent conflicts, but has largely, as Anhard said, been understudied. That is the concept of hostile intent. Troops have the right to fire in self-defense if they encounter hostile intent, which has been defined as, quote, the threat of imminent use of force. It is important to preserve troops' ability to defend themselves, it is also important to recognize the difficulties troops face in determining hostile intent in the heat of combat. This is particularly true in contemporary conflicts in which enemy forces seek to blend in with the civilian population. Nevertheless, erroneous determinations of hostile intent have led to a significant number of casualties in U.S. military operations in Afghanistan and Iraq from 2001 to 2014. A close look at these operations shows that more could have been done to increase the accuracy of hostile intent determinations and reduce the risks to civilians. By learning lessons from Afghanistan and Iraq, the armed forces of the United States, or those of any country for that matter, could increase civilian protection in this area without jeopardizing troops' lives. Doing so would have both humanitarian and strategic benefits. After briefly describing the methodology of my research, I will elaborate on the civilian harm caused by erroneous hostile intent determinations. I will highlight the shortcomings of the rule of hostile intent itself and suggest ways to sharpen it. I will offer recommendations for improving implementation of the rule through better use of tools that can advance civilian protection. And finally, I will discuss the need to establish a permanent and effective process to track and learn from civilian casualty data. My remarks are based on the findings of a report entitled Tackling Tough Calls, Lessons from Recent Conflicts on Hostile Intent and Civilian Protection. It was released earlier this year by the Harvard Law School International Human Rights Clinic, and I was the lead author. Our research came about because NGO colleagues in the field repeatedly cited hostile intent determinations as a driver of civilian casualties in the Afghanistan and Iraq conflicts. We found that while challenges of determining hostile intent were sometimes incorporated in discussions of other civilian casualty issues, a deeper and more focused analysis was warranted. We conducted more than 50 interviews with active duty members of the U.S. military, veterans of the two conflicts, and other experts. The military interviewees came from all four service branches, ranged from specialists to generals, and included those who had served on the front lines all the way to headquarters. We also examined open sources, such as military manuals and UN documents. A review of the civilian casualty data from UNAMA, which is the UN Assistance Mission in Afghanistan, from 2008 to 2014 reveals that the threat erroneous hostile intent determinations pose to civilians. ISAF studies identified some of the similar trends. There were three types of operations: escalation of force procedures, search and seizure operations, especially night raids, and airstrikes that were responsible for the majority of the civilian casualties caused by pro-government forces. Together, the operations caused about 2,050 civilian deaths, which represented almost 70% of those caused by pro-government forces. It's worth noting, however, that the numbers did decline over the years, and anti-government forces caused more civilian casualties overall. The specific number of civilian deaths attributable to misidentifications of hostile intent is unclear, but there's reason for concern. The three types of operations I mentioned frequently require troops to determine whether an individual is demonstrating hostile intent. For example, escalation of force procedures, also known as EOF procedures, are steps taken by troops to ascertain the presence of hostile intent and the permissibility of resorting to force in self-defense. They most frequently arise at checkpoints and with convoys where unknown individuals approach military positions. Search and seizure operations are offensive actions, but can lead to hostile intent situations as well, especially when they are conducted at night. Residents reacting to an unexpected military raid may appear threatening to the troops doing the raid. And finally, unplanned airstrikes, known as opportunity strikes, can be called in by ground forces who need close air support, or they can be initiated by pilots. NATO and the US reportedly made hostile intent a prerequisite for such strikes in Afghanistan, but it can be difficult for a pilot to assess intent from the air. The concept of hostile intent comes from national rules of engagement, not international law. International humanitarian law. Although I'm focusing today on the United States, it is not the only country with rules on this topic. According to the 2005 U.S. Standing Rules of Engagement, the SRO, troops can act in self-defense when they face, quote, a hostile act or demonstrated hostile intent. Hostile intent is then defined as, quote, the threat of imminent use of force. While the right to self-defense should be respected, the U.S. version of the rule is problematic. The U.S. defines imminent as not necessarily immediate or instantaneous. This definition is overly broad and inconsistent with the common understanding of the term imminence. It sets no outside limit on imminence, and a judge advocate who served in Afghanistan and Iraq told us that, read literally, quote, it almost goes to infinity. The definition of imminent is also too vague, which leads to excessive subjectivity. It only defines imminent by what it is not, and provides troops with no further guidance on how to interpret the term. Major Eric Montalvo, a Marine judge advocate who has written on the subject, noted that the, quote, the definition creates more problems than it attempts to solve. He continued, quote, a primary contributor to the civilian casualty problem is a difficulty in assessing hostile intent within a fast-paced combat environment using the SRO's limited explanation of imminence. Troops operating in such fast-paced combat operations would benefit from more clarity on the meaning of hostile intent. A first step would be for the United States to amend the definition of imminent. For example, it could adopt NATO's version, which is, quote, manifest, instant, or overwhelming. This definition would be narrower and leave less room for subjectivity. It would also standardize the rules in joint operations between the U.S. and its allies. The U.S. should in addition provide clearer and more detailed guidelines for how to interpret the SRO's definition. It could build on the tactical directives it issued in Afghanistan that address the three types of operations involving hostile intent and determinations. As I mentioned, those are EOF procedures, night raids, and airstrikes. These two tactical directives, which represented the senior commander's guidance for interpreting the ROE, effectively reduced civilian casualties. For example, one directive limited airstrikes on residential compounds to situations of self-defense when no other options were available. Civilian casualties from airstrikes dropped the following year by 42%. But the directives had limitations. They applied only to operations in Afghanistan, and at least public portions did not address hostile intent in particular. To maximize civilian protection, the U.S. should promulgate more enduring and detailed guidelines that explicitly address the challenges of hostile intent determinations. And they should help clarify how troops should interpret and implement the rule articulated in the SRO. Rules provide a basis for civilian protection, but implementation is also essential. Determining whether an unknown individual is demonstrating hostile intent depends in part on the context of the situation. But in our research, interviewees highlighted three tools for implementation that could help improve the accuracy of hostile intent determinations. They were training, field leadership, and engagement with the local population. Improving training was probably the most common recommendation offered by our military interviewees, and these included active duty personnel and veterans, enlisted men, and senior officers. Training is critical because it provides troops a basis on which to make better decisions in the field. It gives them an opportunity to wrestle with complex scenarios before encountering them in the actual combat. An Army judge advocate told us, quote, "The goal was to minimize situations where soldiers had to make a gut call because they've never experienced the situation before." Multiple sources highlighted the need for extra training on hostile intent. For example, the U.S. Operational Law Handbook from 2015 noted that the concept of hostile intent, quote, "may require additional explanation." Over the course of the past decade, U.S. military training has improved. I visited the Army's National Training Center in California 3 times, the last time in 2007, and I observed significant efforts to design increasingly realistic simulations. For example, the center hired actors who spoke Arabic to play civilians and enemy combatants, constructed mock villages, and added civilians to its scenarios. The images shown here from 2013 demonstrate that the NTC has continued to make efforts towards realism. Our interviewees also reported improvements in training, but they still called for more classroom and scenario training on the specific challenges of hostile intent determinations. They said training would help them respond more appropriately and quickly to difficult situations in the field. Therefore, the U.S. military should institutionalize the improvements to realism of training it has already made, make sure they address hostile intent in particular, and continue to adapt training to new combat missions going forward. Interviewees also highlighted the importance of leadership in influencing how troops understand and apply the rules of engagement, including the rule of hostile intent. Field leaders are particularly important because they have respect of their units and they bring awareness of specific situations on the ground that can affect how hostile intent should be determined. For example, they can warn their units of recent suicide bombings or explain that there have been no bombings in the area for 6 months. Field leaders guide troops on how to operationalize their superior's intent, articulated, for example, in tactical directives. Leaders can also set a tone for the mission, which can include respect for civilian protection. A veteran of Iraq explained, quote, "It's the officer's job to maintain the morality of the mission. Once you let war loose, it's hard to keep it in the bag." Marine Judge Advocate Major Montalvo said, "Leaders can also help troops distinguish between when they can shoot and when they should shoot." Judge advocates and others we spoke with emphasized the need to ensure that field leaders have a clear understanding of the guidelines for implementing the rule of hostile intent in different situations, and that they communicate that understanding to their units, such as through regular ROE briefings. Good leadership can reduce civilian casualties while still protecting troops. Another oft-cited means of improving the accuracy of hostile intent determinations was engagement with the local population. It encompasses cultural training and the development of relationships with people on the ground. Both prongs of engagement increase troops' understanding of common behavior. If troops know what's normal and what should raise red flags, they can better understand an individual's intent. For example, an Army judge advocate stationed in a village in Afghanistan said his troops could easily have thought people working on dikes at 2 a.m. were planting IEDs, but fortunately his troops were aware that the dikes were the residents' only source of water. Similarly, in Iraq, several veterans said troops often felt threatened by people digging at night until they learned that Iraqi farmers work at night because it's too hot during the day. The U.S. made improvements in this area as well over the course of its operations in Afghanistan and Iraq. As mentioned, its pre-deployment training sought more accurately to reflect the local culture, and U.S. forces sometimes partnered with local military or security forces, for example in night raids, to enhance their understanding of the situation on the ground. Going forward, the U.S. military should institutionalize effective methods of engagement while continuing to refine those that need further improvement. They should also be prepared to adapt methods for engaging with the local population to different countries in future conflicts. The end of U.S. operations in Afghanistan and Iraq by 2014 offered us an opportunity to research and reflect on the impact of the U.S. rule of hostile intent on civilian protection. But the U.S. should also do its own evaluations of past and future conduct. Over the last decade, the U.S. has made advances in efforts to learn the lessons of civilian protection. It issued some studies on civilian casualties in Afghanistan and Iraq, including by the Center for Army Lessons Learned and the Joint and Coalition Operational Analysis. It also adopted the Army's Tactics, Techniques, and Procedures on Civilian Casualty Mitigation, a document which comes to several of the same conclusions as our research. Nevertheless, our interviewees said that investigations into hostile intent incidents were rarely in depth. Investigators often gave troops the benefit of the doubt when assessing whether they, quote, reasonably perceived a threat and acted proportionally in response. In turn, troops were sometimes reluctant to volunteer information for fear of repercussions. There are several steps the U.S. military can take to improve its process for learning from civilian casualties. The U.S. should ensure that the goal of investigations into hostile intent incidents is not to punish troops who acted reasonably in self-defense, but to acknowledge and learn from mistakes. Even if a soldier had an honest belief that he or she was facing a hostile situation and his or her shot was lawful, if a civilian casualty resulted, understanding why the error was made is essential to improving the accuracy of hostile intent determinations in the future. The U.S. should also establish a permanent mechanism to track and analyze civilian casualty data. They can look to ISAF's Civilian Casualty Mitigation Team used in Afghanistan as a model. This mechanism should examine hostile intent incidents in particular. Whatever shape the learning process takes, the U.S. military should be as transparent as possible about its findings. The knowledge gathered through investigations and tracking of hostile intent incidents would help the military save civilian lives and protect troops from the trauma of unintentionally killing a civilian. Embracing transparency will build the confidence in the military's intentions and help win support at home and abroad. The U.S. took many commendable steps to increase civilian protection during its operations in Afghanistan and Iraq. But with regard to the particularly challenging problem of hostile intent, it could have done more to prevent erroneous determinations of hostile intent that can lead to unnecessary civilian deaths. Going forward, it should both institutionalize past reforms to ensure they are not limited to specific conflicts and look for additional ways in which to improve. It should also be sure that its tools for implementation address the problems of hostile intent in particular, and not just the problems of civilian casualties more broadly. Lessons learned from Afghanistan and Iraq should inform other U.S. operations as well as its training of foreign security forces. The lessons are also relevant for other militaries, since all combat troops will face challenges in knowing when to use force in self-defense. Finally, information may be useful to humanitarian actors who can assess the application of the rule of hostile intent on the ground, as well as educate civilians about the danger of demonstrating hostile intent, and to help them avoid appearing hostile when they have no such intent. So I wanted to leave plenty of time for online discussion, and I'm happy to answer any questions or hear any thoughts from those of you online. Thank you.
Excellent. Thank you so much, Bonnie. That was really interesting, and thank you for sharing your analysis and recommendations. We do have a number of questions that have come in. I'm going to start with one which, I mean, maybe it's a question of clarification, but I think it's worth probably worth delving into a little bit here, just to make sure that we're clear. So if we're talking about rules of engagement, so these I think are perhaps often seen as being more restrictive than rules of IHL. So rules of engagement perhaps intending to ensure the application of IHL by national armed forces, among other things, other considerations. As you understand it, or in your view, does the determination of hostile intent need to meet all of the conditions that determines civilian direct participation in hostilities, so threshold of harm, direct causation, belligerent nexus? What would you see, or in other words, what would you see as the difference between hostile intent, rules of engagement term, and civilian direct participation in hostilities, which would be an IHL term? Sorry, I hope that was clear enough. Over to you.
Thanks. That was very clear, and a question actually I was hoping I would get. So I'm glad someone asked it. So the interaction between IHL and rules of engagement here is very interesting. So I mentioned and you mentioned, reiterated, hostile intent comes from the rules of engagement, but does not appear in international law, which in some ways is surprising that IHL does not comment on the issue of self-defense. The issue of direct participation in hostilities is often confused with hostile intent, or maybe not confused, but conflated. And there's actually in the ICRC, I believe it's in the ICRC guidelines on DPH, there's a footnote saying that it's dangerous to conflate the two. That said, in some ways, that's exactly what's going on in the U.S. situation. The U.S. does not agree with the ICRC's interpretation of the direct participation in hostilities, and it tends to use the term hostile intent when referring to situations of civilian casualties, and rarely cites DPH as a cause. So, and I've heard this from high-level military officials that the term when they hear about civilian casualties, they immediately think, oh, it must be a self-defense situation, it must be hostile intent, rather than saying, oh, the civilian or the individual that was killed was a civilian directly participating in hostilities. This, of course, raises questions about the role of IHL at the domestic level and the need for that not to be forgotten by all means. And I think the distinction is that hostile intent, in some ways, they're not mutually exclusive. Hostile intent is a response to a specific situation, while DPH is more of a status determination. But I think, as I said, I think it's important that IHL not be forgotten in this situation, as well as it's important to continue to sharpen the hostile intent determination, since those are what, at least in the U.S., is the common framework in which to understand civilian casualties.
Excellent, thanks. So I know that you've been, of course, looking primarily at the U.S., but we did have a question from Andreas. If you're able to speak to it, I don't know, but how armed forces of other countries apart from the U.S. have approached the issue. So in particular, other NATO member states, but Andreas was also wondering about the Russian armed forces. Would you have anything to share regarding how, or other potential or actual approaches to the issue from other states' perspectives?
I think that's an issue that definitely needs to be examined more, and my understanding is that there is some research that's going on in that area. We originally had hoped to do a comparative analysis, but just due to the needs to limit our research to a more manageable scale, decided just to focus on the U.S. So I don't have too much information to add, and I certainly don't have any awareness of the Russian the Russian view of hostile intent. The one thing I would point out, though, is that I think there is a difference in that we heard a lot of people saying, "Oh, the U.S. is sort of alone out there in Afghanistan in its interpretation that there's a and it specifically says in the U.S. operational handbook that it does not agree with NATO on the rule of hostile intent. So it's very explicit about that. As I mentioned, the NATO definition of imminent is much narrower. It's manifest, instant, or overwhelming, which is certainly a far cry from not necessarily immediate or instantaneous. So while I don't know the rules within member states, at least at the NATO level as a whole, there's a difference in interpretation. So I definitely think it's an area that warrants more research, and I hope that is done. But that's pretty much what I have on the comparative analysis at this point.
Okay, great. We also had, so let's see, from Alan, we had a question regarding the figures that you shared with us regarding civilian casualties, and he was wondering, so he's pointing out that the occurrence of civilian casualties does not necessarily equal an erroneous hostile intent determination, and he's wondering if the figures that you've been looking at are limited to incidents in which the civilians killed were actually themselves being targeted, as opposed to being collateral damage when others were targeted.
Yeah, so that's another great question. So unfortunately, there's no data, and we weren't doing. There's no data that we could find that specifically addresses erroneous hostile intent determinations, and that's definitely an area that I hope further research will be done into, and that's one reason we believe it's so important for the U.S. and others to establish tracking cells that specifically break down civilian casualty data, including by whether hostile intent determinations were the cause. What we did do, however, was look at the as I mentioned, three categories of operations that frequently or even inherently in the EOF case require hostile intent determinations. So, I wouldn't contend that all civilian casualties from those operations were attributable to erroneous hostile intent determinations. The fact that they frequently require hostile determinations suggests that there's reasons for concern. So, for example, EOF incidents, it's basically a process for determining whether there's hostile act or hostile intent. So that's very likely. And as I mentioned, the airstrikes, the U.S. and NATO required, or maybe U.S. and ASAF, I believe, required that hostile intent, after a certain point, that hostile intent be a prerequisite to an unplanned airstrike. So I agree more research needs to be done into specific numbers, but we felt there was enough of a trend to warrant the conclusion that this is indeed a problem, and therefore to start looking at how it could be better, the rule could be sharpened and better implemented in the field.
Okay, excellent, thanks. Maybe so a follow-up then, this is also a question from Alan. So acknowledging that the concept of imminence is indeed flexible, as you were saying, and perhaps necessarily so. But you're talking about sharpening the concept, perhaps could be considered narrowing. Alan is wondering, how is it that narrowing the concept of imminence would not necessarily force troops to incur more risk of being wrong, if that makes sense? So how, if your recommendations were implemented, would that not put troops at additional risk?
Great. So I think sharpening and indeed narrowing imminence is a crucial part of our recommendations. There's, in return to the effect on troops, I have a couple comments. First of all, troops, as you said, first of all, that there is a certain flexibility required in making hostile intent determinations, and what's hostile is hostile in one context may not be in another. It's very context specific. So, for example, if it's very rare to carry guns in a certain area and someone's carrying, this is a crude example, but if rare to carry guns in a certain country and someone's carrying them, that might be hostile, whereas in a country where everyone's carrying guns, that's not the case. So I want to continue to allow that flexibility. But when we spoke to troops, they seem to want more specific guidelines and to know better what to do. So in terms of the increased risk, to a certain extent, that's true. If you have fewer cases in which you can fire, there is a certain amount of risk. However, it's important to keep in mind that most troops do not want to kill civilians. That when I talked to people, they were concerned about the trauma involved with killing a civilian or injuring a civilian when they had no intention to do so. So I think creating a more accurate determinations actually has some benefits for troops, at least their psychological health, if not their physical health. Second, there's a strategic advantage. Well, the focus of our research was on humanitarian, reducing civilian casualties. There's definitely a strategic benefit to not wrongfully killing civilians in the sense that it can help, that can undermine winning of hearts and minds and make particularly counterinsurgency operations more difficult. When I presented this research before a U.S. Army audience, particularly of judge advocates, they very much were receptive to the strategic argument. That said, there was a very compelling intervention by an officer on the ground who was worried particularly not so much about his self-defense, but about unit self-defense, this defense of his soldiers. So I think that's something that needs to be taken into account, because it's different to just put yourself at risk than to put your soldiers at risk. So I think in the long run, sharpening the concept is essential, and it recognizes that there could be some level of risk, but I feel that the risk is not undue given to all the benefits and the fact that we're not eliminating the rule of hostile intent. We're just trying to make it more precise, for example, in the way NATO has done.
Okay, excellent. Thank you. We have a question from David, who is wondering if you would have any specific examples that you could share with us that illustrate improvements in understanding of hostile intent on the ground from Afghanistan or Iraq. So you were speaking about improvements in training and so on. Are there any examples of improvement in that understanding and what the effects have been on the ground, or is it still something to be seen, would you say?
I think there's improvement in general in the engagement with the local population, which I think directly has an impact on the accuracy of hostile intent determinations. Troops talked about, I'm trying to think of a specific example, but troops talked about the importance that when that earlier on in the period we were studying, it seemed like there was less emphasis on getting the soldiers out to meet and speak with civilians or leaders of communities, and there was also less effective cultural training back at base. So, but troops also really highlighted that when they had a better understanding, it did make a difference for them. So I don't have a specific example of someone who served in 2005 and said he saw a lot of poor hostile intent determinations, and not the case later. But I think indirectly the evidence of better understanding of the incidents does suggest that an improvement in that area. I'm trying to think of a specific example from the report, but that's sort of the general theme. One example I will point out, though, is that I believe it was an Army officer who served on multiple tours, said that his proudest moment was when, I think, as I recall, that one of his members in his unit entered a house and a kid picked up a gun, and the fact that the soldier was able to, rather than instantly fire, which would have been a legitimate response, and that goes to when troops can fire, he was able to instead realize that this was maybe not as hostile a situation as it seemed, and to disarm the child before anyone was put in harm's way. So I think there's a recognition of the importance of avoiding these civilian casualties, and that was one example of where the tone of the operation, this interest in avoiding unnecessary hostile intent determinations has been inculcated.
Okay, great, thank you. So a question now from Amy, who is wondering if special forces have different rules, basically. Or if there's a different different expectations in terms of interpretation or different guidance for special forces as opposed to other troops in dealing with the issue of hostile intent.
That's a great question. I don't know for sure. I do know that we did interview some special forces, and they didn't give any indication that they did have different rules. Obviously, the specifics vary conflict to conflict, but so I have no indication that they did have different rules on hostile intent and self-defense. They possibly implementing them in a different way, but if anything, I know this isn't a special forces question, but Marines versus Army, the Marines I spoke with emphasized, at least in their opinion, that they made a much greater effort to positively identify a target before firing. So I didn't do scientific research into the comparison. I don't want to, I know there's rivalry between the service branches, and I don't want to make conclusions that aren't there. But that was the only distinction I heard was between the Marines and the Army, but I don't know for sure about special forces.
Okay, great, thanks. So let's see, a few more questions coming in here. You create a lot of work for yourself by giving us such a nice a nice period of time for Q&A, but it's very much appreciated.
I hope that's okay.
No, it's terrific. So a question from Richard. Interesting, I think, from the perspective of humanitarian agencies or maybe other actors who would want to develop strategies for protection of civilians. Richard is asking whether communities can be taught how to behave to minimize risks to themselves. Is that something that has come up in the discussions that you've had regarding hostile intent?
It's a question that started to come up. I'm doing some other research for another project on direct participation in hostilities that, as I said, is related but not the same concept. And in that context, there has been I've encountered some discussion about whether humanitarian agencies could help civilians understand, what the rules are, what will be considered direct participation in a certain conflict zone. And I think the same could be applied here. It does seem useful that, humanitarian actors who are on the ground, if they, to the extent that rules are transparent, which I think they should be to the degree allowed, given the humanitarian actors' interaction with civilian population, it would make sense to use that as a vehicle for raising awareness among civilians. I had a question for the humanitarian organizations. Is that something that's consistent with their understanding of advancing civilian protection, because it could seem very practical response, or does it present any ethical issues that they feel that they are basically doing the military's job? The initial research I've done, I think more is warranted, but the initial research I've done is that some of the agencies I talked to did not see a problem with that they thought it could be a useful way to advance civilian protection, but I haven't done, I think more interviews would be warranted just to see if other actors felt that way.
Very interesting, and yes, I mean, for anyone currently in the session live who is working in the humanitarian organization, I know that there are many of you who may have opinions on that. Feel free to post in the chat and contribute to the conversation in that way. We have another question from a Richard, but a different Richard, regarding mechanisms for redress in cases of erroneous interpretation of hostile intent or erroneous determination. Are there such mechanisms in place?
I'm not sure if there's specifically any for erroneous determinations of hostile intent. I think obviously there's certain mechanisms in the U.S. and in other countries for unlawful killing of civilians. I think, as I mentioned, that there's a great deference to self-defense, and that's perhaps as it should be, that if a soldier reasonably believed he or she was acting in self-defense, and the belief was reasonable, that prosecution is not the goal. That said, I think in learning lessons about hostile intent, it's more important to create an environment where we can figure out why determinations were erroneous, rather than prosecute what might be a reasonable belief. So I think more investigations are needed in terms of redress specifically for this. I don't think it differs in this score than anything and any other mechanisms for civilian casualties.
Okay. All right, great. So you mentioned, I mean, again, drawing the distinction between the issue of determination of hostile intent and then looking at actual violations of the law. But it brings me, I think, to a kind of follow-up question from Margot, who's bothered still by this distinction between the concept of hostile intent versus civilian direct participation in hostilities. And she is wondering if she can push on that question a little bit to ask you, what is actually the legal basis in international law? Is there a legal basis in international law for self-defense against hostile intent?
To my understanding, there, at least in IHL specifically, that there isn't necessarily an international law legal basis for individual self-defense. In for example, the Geneva Conventions, I mean, there's a whole discussion which we didn't get into about the issue of like national self-defense and whether self-defense can be preemptive and so forth. I think some parallels can be drawn with the individual case, and some of that comes from, at least is discussed at an international law level, although I think the rules have been, it's a hotly debated and very politicized topic. So we try to separate the individual focus on self-defense from the national self-defense. So I think the national level has had more discussion at the international law level than the individual. So as far as I know, it's not recognized. Perhaps it should be. It does seem legitimate to allow someone to act in self-defense, but the DPH tends, understandably also, tends to be a key rule that should not be forgotten.
Okay, great, thank you. So now going back to different definitions or conceptions of hostile intent, we have a question from David wondering if you would support the outright adoption by the U.S. of the NATO definition of hostile intent, or would you rather have other suggestions on how to, quote, sharpen it?
I think that I think the NATO definition would be a significant improvement and could be adequate. I feel like I'd want to, before I made that the definitive answer, I'd want to do some comparative research into how effective NATO's definition has been, just because if I haven't proven that or researched that, it's hard to say for sure, but I definitely think it would be an improvement. Another thing I didn't get into was that earlier rules, standing rules on U.S. rules on use of force in other contexts have a slightly different and more specific understanding of hostile intent and imminence, and they require it to show both. They require a requirement of both showing capacity and capacity and intent, and even that would be more specific than just requiring instantaneous. So I think and it's unclear why the rules have been weakened in the U.S. gradually over time. So, I don't have that language at my fingertips. I think there's a couple routes that could be followed in terms of increasing or narrowing the definition of hostile intent. I think the NATO is probably the narrowest that I've read, but there might be other ways to go about it.
Okay, great. So now let's see. So going back to So you've mentioned a few different sort of practical measures that can be taken, but anywhere from sort of adjusting or improving the definition of the concept to training of troops, and then also to kind of improving understanding of local cultures where troops are on the ground, are active. We have a question from Jamal, who is wondering, I guess, in this whole spectrum of actions that could be taken to improve protection of civilians, how important is that cultural understanding piece? So relatively speaking, how important is it in that broader context to train combatants in understanding foreign cultures? And he brings up, of course, the example of cultural display of weapons. So the instances in Afghanistan where wedding congregations were bombed because they were displaying weapons, while that's part of Afghan culture. So how would you respond?
I think culture is crucial, and in some ways it relates with training. I think the number one response when I asked interviewees about what their recommendations were, they came up with training first, but part of training should be training on culture. So I think they go together. Culture is so essential, just as you mentioned, for the gun example, because if you don't know what's normal in a situation, how can you possibly know how to judge intent? Another example that a soldier gave was, if all the kids are out playing soccer, then it's probably safe to go out that day, but suddenly no one's playing soccer or football, and they see one isolated person out there maybe looking a little suspicious for whatever reason. That creates a different understanding of the situation, because it suggests that the locals know something's going on, and so you have to listen to what the local understanding of a situation is. So I think it's crucial, and I think it's also important to note that it needs to constantly be amended as U.S. or other countries operate in different conflict zones, or even different places within a country. Or different times in a country. I heard a lot of troops saying, well, we had different rules in Afghanistan and Iraq, or different rules even within Baghdad, or different rules within different people who served on multiple tours at different times within the Iraq conflict. So there's a lot of context to take into account, and culture is certainly a key part of it.
Okay, great. A follow-up question on training, and you mentioned that there are improvements in training. The question is the problem that there's too little training of U.S. forces, or actually that it's the wrong kind, that the focus needs to shift somehow?
I mean, I think there's extensive training, so I wouldn't say necessarily there's too little training in general. I think it's more focusing it. In the interviews we did, there was few examples of hostile intent being addressed specifically, despite the operational law handbook even saying that is an area that needs extra attention. Some interviewees described it as basically a PowerPoint slide or two somewhere in the course of their training, but that's not. It needs much more than that to really grasp the complexity of the concept and different ways, prepare troops to implement it on the ground. So I think it's not just a quantity, but a focus of training that needs to be changed.
Okay. Great. So we have now a follow-up question on the displaying weapons in the context of a wedding celebration scenario. And the question is perhaps a tricky one. So whether commanders could be prosecuted in the ICC for an act of targeting civilians who were not directly participating in hostilities, but were displaying weapons as part of a wedding celebration consistent with their culture. In that kind of situation, so how do we understand the interaction between international law and that commander acting according to his or her rules of engagement and understanding of hostile intent?
Well, I think the ICC draws its elements from IHL, so it doesn't necessarily discuss self-defense or as far as I know, I'm not an international criminal expert, but it doesn't deal with domestic rules of engagement such as that we're discussing today. So I would think that there's a likelihood that if a commander, and usually criminal law requires a certain level of intent, so if the commander knew or should have known that the wedding party was a wedding party and still fired, then that would very likely rise to the level of a war crime. There might be a lower level that maybe it's not a criminal act, but it's still a violation of IHL. So I don't think there's definitely roots for prosecuting those examples that might be a violation of the hostile intent rule as well as the DPH rule, but it needs to have a level of intent behind the killing of civilians, and also meet the elements of the ICC which come from international humanitarian law.
Okay, great, thank you. Okay, so we have time for one or two more questions. We're actually, yes, racing up on the end of our hour. But so both Jamal and Richard do have follow-up questions on what we were discussing a few minutes ago, the idea of enhancing protection of civilians by actually coaching or teaching communities in terms of their practical behavior to avoid erroneous determinations of hostile intent. Richard, wondering in particular, based on your research, would there be any specific practical behavior that you would recommend that communities could take up, or that those concerned with enhancing their protection could recommend to them?
I think that there probably is behavior, but I think it's context specific. Because it, again, as hostile intent, what's understood as hostile depends on the context in which it occurs. So troops need to be aware communities need to be aware of what might appear hostile in their at the specific time, in their specific context, in their specific culture. So I think when we got down at that level, there'd be very likely, I mean, you can use the weapons example again, although we can overuse that example, but I think in a case of like digging at night, you could warn civilians that has been misinterpreted if it has. But again, the burden should be on the military in that case if it's a common cultural practice, to learn about that and respect it. So there's a combination of giving practical advice to communities that this is a perfectly, digging at night's perfectly legitimate, but beware, it's sometimes been misinterpreted. So it's not a legal duty, but a practical suggestion. But then leaving the burden on militaries to learn about the culture and the context in order to improve their determinations.
Okay, great, thank you. So I don't want to run over time, so I think we should probably call it a session. But I would very much welcome you, Bonnie, if you have any closing remarks to share with us. It's been a very intensive Q&A, and as you can see, there's certainly a lot of really active concern, I think, from different parts of this international community that we're speaking with today. But perhaps you could say a few words in closing about what's happening next for you. So where is your research taking you next, and what are you looking ahead to on the horizon on this issue?
Well, thank you, first of all, very much for having me and for all the great questions. I really appreciate the dialogue. I think that it's a challenging topic, and the questions were all very insightful. In terms of my research, I don't have a specific project on hostile intent in the works, although, as I said, I think that I hope someone will be doing research in comparative research in other countries. And I think that it's an area that would warrant further research by our program or others as operations continue in today in different some of the same areas, but different conflicts. And one area, though, that we are researching, as I mentioned briefly, is direct participation in hostilities. We were part of a study released by Civic, I think it's been about a year and a half ago, that offered a civilian perspective on how DPH should be understood. So we were part of that study, and we're hoping to do some follow-up work to that project. And in the course of that, it's interesting that how many intersections I've seen, even though my first reaction was to divide them completely. I think the fact that the U.S. military is in some ways conflating them, that it's important to keep the comparison in mind. So that's sort of one of my next projects. And from there, I look forward to seeing where else this research will take us.
All right, excellent. Thank you so much. Thanks again, Bonnie Docherty, for being with us today. A really interesting session, and I think a really rich discussion in particular. Thanks to all of our participants for being with us. The recording of today's event will be available very soon, within the coming days, at the link that you see in front of you there, in case you would like to review any of the discussion or the presentation of the research that will be available to you, or you can share it also with colleagues who are interested. I'll also highlight for you our next event coming up in our series looking at humanitarian law and policy. Our next online learning session is on the topic of the legal dilemma of detention in non-international armed conflicts, and that will be with Gabor Rona as our guest speaker. Gabor is a visiting professor at Cardozo Law School. If you will be joining that session, you'll receive an introduction to the legal frameworks applicable to detention in armed conflict situations that are non-international in nature, and looking at the legal debate regarding detention in these situations in which international humanitarian law is considered neither authorizing nor regulating detention. So there's perhaps a paucity of law applying to some of the practices of detention in non-international armed conflicts. So certainly hope that you will consider joining us for that. And otherwise, we will continue to keep you updated regarding other events coming up in the series on humanitarian law and policy, closing out this year, and then looking ahead to a new series in 2017. So thanks again, all of you, for being with us. Thanks to Bonnie, and this is Ann Lang signing off today from Dubai, but I'll be back in Geneva next week. All right, bye-bye for now, and see you next time.